Okay, this is the case brief over the Supreme Court of the United States. Petitioner Cuauhtemoc versus Gonzalez-Lopez. Justice Scalia delivered the opinion of the court. Respondent Cuauhtemoc Gonzalez-Lopez was charged in the Eastern District of Missouri with conspiracy to distribute more than 100 kilograms of marijuana. His family hired John Fale to represent him. After the arraignment, respondent called a California attorney, Joseph Lowe, to discuss whether Lowe would represent him. Either in addition to or instead of Fale. Lowe flew down from California to meet with respondent who hired him. Later, Lowe and Fale represented respondent in an evidentiary hearing before a magistrate judge. The magistrate judge accepted Lowe's provisional entry of appearance and permitted Lowe to participate in the hearing on the condition that he immediately file a motion for admission pro hac vice. During the hearing, however, the magistrate judge revoked the provisional acceptance on the ground that by passing notes to Fale, Lowe had violated a court rule restricting the cross-examination of a witness to one counsel. So this is the rule that was violated in the case. This is a Missouri rule. I think specifically it is Missouri Rule 4-4.2. So then Fale withdraws from the case. It says the district court granted Fale's motion to withdraw and granted a continuance so that respondent could find new representation. Respondent retained the local attorney, Carl Dickhouse, for the trial. The district court then denied Lowe's motion to strike and, for the first time, explained that it denied Lowe's motions for admission pro hac vice primarily because in a separate case before it, Lowe had violated Rule 4-4.2 by communicating with the representing party. Case proceeded to trial and Dickhouse represented respondent. Lowe again moved for admission and was again denied. The court also denied Dickhouse's request to have Lowe at counsel table with him and ordered Lowe to sit in the audience and to have no contact with Dickhouse during the proceedings. To enforce the court's order, a United States Marshal sat between Lowe and Dickhouse at the trial. Respondent was unable to meet with Lowe throughout the trial except for once on the last night. The jury found respondent guilty. After trial, the district court granted Fale's motion for sanctions against Lowe. It read Rule 4-4.2 to forbid Lowe's contact with respondent without Fale's permission. It also reiterated that it had denied Lowe's motions for admission on the ground that Lowe had violated the same rule in a separate manner. Respondent appealed and the 8th Circuit vacated the conviction. The court first held that the district court erred in interpreting Rule 4-4.2 to prohibit Lowe's conduct both in this case and in the separate manner of which the district court based its denials of his admission motions. The district court's denials of those motions were therefore erroneous and violated respondent's Sixth Amendment right to paid counsel of his choosing. The court then concluded that this Sixth Amendment violation was not subject to harmless error review. We granted certiorari. Then it goes on to explain some specifics about counsel choices which aren't relevant to the case. Justice Scalia dissented. He argued a couple of things. He said the purpose of the Confrontation Clause was to ensure the reliability of the evidence. Confrontation Clause was not violated. He says that it should be Confrontation Clause commands not that evidence be reliable, but that reliability be assessed in a particular manner by testing in the crucible of cross-examination. Says the Constitution guarantees a free and fair trial through due process clauses, but it defines the basic elements of a fair trial largely through the several provisions of the Sixth Amendment, including the counsel clause. Yeah, most of this is just explaining the rules and the cases related to their decision. It says towards the end that it's not relevant. Deprivation of the right is complete when the defendant is erroneously prevented from being represented by the lawyer he wants, regardless of the quality of the representation he received. So that's when the right is completely violated. Then it talks about two different classes of constitutional errors, which were trial errors and structural defects, which I won't define. Government acknowledges that the deprivation of choice of counsel pervades the entire trial, but points out that the counsel's ineffectiveness may also do so, and yet we do not allow reversal of a conviction for that reason without a showing of prejudice. And that's the end of Justice Scalia's dissent, and really sums up most of what he said. Even the dissent discusses that the defendant had no right to choose counsel. It says the court has an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. And then, yeah, again, it says none of these limitations of the right to choose counsel apply here. Government conceded that the district court here erred when it denied respondent his choice of counsel. Accepting that premise, we hold that the error violated respondent's Sixth Amendment right to counsel of choice, and that his violation is not subject to harmless error analysis. Judgment of the Court of Appeals is affirmed, and the case is remanded for further proceeding consistent with this opinion. It is so ordered. Thank you.